Welcome to What to Do When, a podcast from real lawyers with real perspective, where we explore a variety of legal issues and scenarios. Each week, we focus on a new topic and discuss what to do when and if any of these legal scenarios ever happen to you or a loved one. With over 40 years of combined legal experience, our hosts offer their unique perspectives and insights on a range of real-life legal situations.
Hi, and welcome back to What to Do When, a podcast here at Critzer, Cardani in Richmond, Virginia. I'm Jackie Critzer. This is Scott Cardani.
How you doing? Jackie, what's on the docket for today?
Today we're talking about what to do when depositions happen.
Depositions?
Right.
What are depositions?
It's a big fancy word, right? You hear it in all the legal TV shows. Oh, depositions, this, that, and it's sort of this big to-do. But that's a great question. What are depositions?
You know, they're kind of like an attorney's chance to ask all the questions he ever wanted to ask prior to trial. And they're a way to get what we call discovery, information about the case. So it's a chance to either get one of the parties, if you don't know what a party is, like if Jackie and I were in a divorce, she'd be one party and I'd be the other party. So it's the two people in the lawsuit or the two companies in the lawsuit or whoever it may be in the lawsuit. So you have that aspect. So, and then you have potential witnesses in that trial. So discovery is a chance to kind of get a verbal take, because we often do written discovery answers and questions, and sometimes this is a way to follow up on those questions you ask, and sometimes it's just a run at the witness or the other party to see, maybe run your theory, maybe run your ideas and see how they play out. So that's kind of one aspect. What's anything else, Jackie?
Well, I think too, you've got the parties, right? But it's sworn testimony, so it's under oath. You're sworn in. I swear to tell the truth. There's no judge there. It's just the attorneys and the person or people being deposed. And the point is to try to get as much information as you can to move the case forward towards trial. But part of that process means that if person answers a certain way in depositions and in trial answers a totally different way, well, then you can use the depositions to impeach them or to show that they're lying at trial, or at least ask them to explain the difference in their answer to the exact same question. And that can be very helpful, of course, in succeeding in at least impeaching that person's testimony and discrediting them in front of a judge or a jury.
Mm-hmm. So, just so we're clear, the deposition is a non-court event, usually in an attorney's office where you're under oath with a court reporter. Like she said, she'll swear you in, say, do you swear to tell the truth, the whole truth, nothing but the truth? And some people use so help me God still, and some people don't, but that's the deal. And so we're there. Your attorney, who will be there? Let me ask that.
Well,
who's with you?
So your attorney is with you. The other party, so the other litigant, so plaintiff and defendant with their attorneys, if there are any. And if the parties aren't being deposed, if it's not the plaintiff or the defendant, they can still be in the room because they're parties to the case. And let's just say it's a witness for one of the people. They can come in. But aside from the parties and their attorneys and the court reporter, there shouldn't be anybody else in the room unless that person's being deposed.
And just to be clear, Jackie said the witness. There may be a witness coming in to be deposed. In that case, like, say Jackie's uncle is the person who caught me doing something wrong in the divorce. So he's going to testify, so he's going to come into depositions. Jackie's uncle will be in the deposition. Jackie, myself, and our two attorneys will be in the depositions.
Exactly right.
That witness can't just sit in there while I'm deposing Jackie, because
right.
Like in a courtroom, a deposition is operated much like a courtroom, and what I'm saying by that is we normally, in a case where we have witnesses, we exclude the witnesses from the courtroom prior to starting the trial, so one witness goes at a time. And the reason we do that is so that the witness's testimony isn't influenced by the other testimony.
Exactly right.
Or they're not given keys on what to say or something like that. So basically, it keeps the testimony honest, straightforward, and from their perspective. And the idea is not to cloud it or color it somehow, or to have some plan in cahoots.
Right. Well, and I will say, too, that in depositions, the rules are a little different, right, than in court. So the rules of evidence that that, when you're watching TV, objection, whatever the objection is at the time, those don't really apply to depositions, but for a very narrow exception. And why is that? Why don't the rules of evidence apply in depositions?
Because it's discovery and it's not a court. That's the number one reason. But the other reason is they actually apply, but you don't have a judge to litigate it. So it really kind of becomes a hindrance. And what you can do is I still object on the record, and then I can make that part of the transcript not be allowed to come in and things like that based on the judge. And sometimes you have to get a judge involved during the depositions. Maybe somebody refuses to answer.
Yep, yes.
And you have to make a phone call to the judge. Hey, we're doing depositions today. Johnny was not going to answer this question. The judge can make a ruling right there. We can go back on the record and do that. But that becomes really burdensome. Sometimes it's better to object and figure it out later. There's just lots of strategies that you and your attorney, us, will talk about. So,
but speaking of strategies, right?
Yep.
So what's the purpose? I mean, we talked about potential impeachment during a trial, but why else are you really calling for depositions in a case?
I honestly think that's probably, there's two to me that are primal. Number one is that kind of getting them to say something different than they may say at trial and tracking that. But the other one is to get more discovery. For instance, say I send out a questionnaire to Jackie and I said, in my written discoveries, which are called interrogatories, as all the word means question, just like you learned in grammar school, interrogatory is a question. So I have so many questions I can ask her in written form, and she has to answer. So maybe she answered, I said, where were you on October 31st at 1 a.m. in the morning? And she answers, in Texas. So in depositions, I can go, okay, Jackie, you answered that you were in Texas on October 31st. Where were you in Texas? And she goes, well, I don't know. Were you at a hotel, Jackie? And I can start digging into where she was. Who were you with? Why were you there? And it may turn out to be completely innocent. She may say, well, I was at a conference. What do you mean? And
sure,
I was with my daughter. She was in the hotel room. It may turn out to be your benefit. But the idea is for us to dig a little deeper sometimes to find a little more discovery that we didn't get in those answers, or maybe even a question we didn't ask. Because maybe when we sent out discovery, let me say it this way. Sometimes when you send out discovery, you get answers that create more questions.
Sure. Oh, that's true.
And even different questions. So sometimes this deposition is going to be like, wow, I need to ask this question. I need to figure out why she answered this way. And so you're just digging deeper, to try to resolve the case, to try to prove your evidence in the case. And ultimately, a good deposition can sometimes lead to settlement.
I think that's true too. Sometimes in the request for production of documents, still part of discovery, you might get 12 months or 24 months of bank statements in any kind of case, right? It doesn't have to be just divorce. It could be really any civil case. And you might see some deposits that are strange. You might see, say, payroll deposits, and then you see these other maybe large cash deposits or large cash withdrawals. And you want to ask questions about that because maybe that leads to the next piece of your case, whatever the case may be. But it is a way to expand whatever information you've already received. And it's really best used to dig a little deeper into discovery that's already been issued. We wouldn't do depositions at the beginning of a case. You would do depositions after, other forms of discovery, I think, had been used.
I think so, too. And I think one of the things I see most often is two things. There are sometimes people who are very unprepared in depositions, and I mean the counsel, the attorneys, and it becomes really random, it's everywhere. That's hard for all parties, honestly. It's hard for you as the person being deposed to track what he's talking about. It's also hard for the attorneys to track where it's going, and it just becomes really a confusing sort of mess. But again, it can lead you to trip up and say something different than what you really meant because of the way the questions are answered. So you have to really be careful when you're answering questions. And I always tell people this, slow down. If you have to repeat the question in your head, you're not in a race. And what people try to do, even in courtrooms, is you try to get people going and get them going and get them answering questions. And then you throw in a softball question or a hardball question or a complete trick. And they may answer the way you want them to. And so people fall for that. But you always need to just be aware This is not a big deal. I can handle this. And when they're asking the questions, you can control the pace by slowing it down and say, okay, he asked me where it was on October 31st. Let me answer that. Is there any time you shouldn't answer a question?
When your attorney objects, you should maybe not answer the question, right? You just sit and wait. If the attorneys start talking over each other, which we do from time to time, stop talking. Let the attorneys figure out what needs to happen next. And if you are then directed to provide an answer and your attorney is in agreement, then provide the answer. But you definitely want to stop when your attorney steps in, or if you're unsure. Another time is if you're unsure what the question really is asking. Sometimes we attorneys don't mean to be confusing. Sometimes we mean to be confusing. And so if you, the person being deposed, don't really understand the question being asked, then don't answer the question you think is being asked. Get a clarification.
Yes, very much so. That's
because
so important.
If the attorney is asking, how is it going to read in a transcript, right? The attorney's asked the question, you think you know. Well, I'm trying to decipher, okay, I think I know what was being asked, and then you answer, and then you go back and you read, oh, that wasn't the question you were asking, and now it looks like something totally different. You don't want that. You can walk it back, but it's far more difficult. It's much better to just say, I'm not really sure what you're asking me in that question. So that would be another time not to answer right away.
Absolutely. And you got to remember that, folks. It's just like on a test sometimes. All of us take a test where we thought the professor or the teacher was asking us one thing, and we answered a certain way because we made some assumptions. And what we're trying to guard against is that really you shouldn't make any assumptions in a deposition, especially if you're being deposed, because it's the attorney's job to make that question very crystal clear, so you answer a crystal clear question. And if he can't do that, I actually was in a deposition one time where the deposer, we'll call them, really was having trouble stringing together 3 sentences, and I'm not joking. And it was and I just kept telling my guy, he kept looking at me, should I try to, no, don't answer it. She needs to ask an articulable question. And if they can't do that, you don't have to answer something that you're guessing about. And that may take some time, but again, you have no pressure in this. Don't feel pressure. You're already there. It's already a bad situation from your perspective because you don't want to tell your story again. And sometimes stories are really rough to tell, so it makes it very difficult.
Is there a time in a criminal case, Scott, that you might find depositions useful? And if so, what sort of scenario might that be helpful?
I think for me, I've almost never used them in criminal cases. And for lots of reasons. I don't know. Some guys use them, and I think sometimes we use them for witnesses to get their story down and make sure you have the story so when they go into court they don't change that story. That might be a way to do that. But for the most part in criminal cases, I don't think they're effective or fruitful. And quite frankly, in criminal cases, people change their story all the time.
And so
parties.
I would say, I do mostly civil work anyway, but I would say that depositions are most useful in civil cases, and it's with witnesses and with parties. I've used depositions also in bankruptcy litigation, I wouldn't use it in a normal bankruptcy case. That's strange. That's just weird. But in a bankruptcy litigation case, I have been able to use depositions, and very effectively. So same concept, expanding on the discovery that's already been asked. Sometimes you want to go over their answers in the pleadings, right? So I file a complaint against Scott's client, and Scott's client says, oh yeah, well, here's my answer, and also a cross complaint or a counterclaim against my client. And so it's a way to dig into those answers as well, and to flesh out, where did that come from? How did that happen? Which wouldn't necessarily be uncovered in discovery, or maybe it would be. So it can be a useful tool, I would say, most civil cases.
I want to ask a couple more questions I think are important for people to understand. Can you have somebody in the deposition with you, like, say, a family member, a friend, because you're nervous?
Like for moral support?
Yeah.
The answer is it depends, and it depends on whether the person is a witness in the case. If they're a witness in the case, I'm sure the attorneys are going to say, no way that person can't be in here. No way. If they're
and every judge is going to say the same thing.
Completely.
Yes.
If they're not a witness, then the answer
never
is
will be.
And no chance that they will be, right? Who can predict that? That's the catch. Who can predict that person is never going to be a witness, especially if they're there, they're familiar with you, they're familiar with the situation. is there some potential that maybe they could be a witness somewhere down the line? And if I'm the attorney who's being asked, can this person sit in here? Most of the time I'm going to say, no. You can influence, that person might influence their answers. That person might one day become a witness, and we didn't realize it at the time of depositions, but now, no. Most of the time, I think most lawyers are going to say, no, you can't have, your attorney is your moral support. That's who you get.
And, you can have the situation, and I know this happens quite often. Jackie's here for my moral support, and I'm talking about my trip to Cancun, and she has no idea at first, and all of a sudden she, flashes, and I see as the other attorney, she knows something, and all of a sudden she's a witness because I may need to depose her now. So, if they're your good friend, they probably know more than you think they know, and those kind of things. So, they're not that tough. I mean, normally depositions are pretty low key, in the sense of they're not like a courtroom. They are pretty tough, but they're not. They are more low key. What about video? Deposition. What about video? Everything since COVID, everybody wants to do video depositions and be away.
So I actually participated in Zoom depositions, and I'll tell you, I thought it was very difficult to really get a grid on the person I was deposing, because the person I was deposing and the attorney were on two different cameras, and I will say that there were times where I asked the court reporter to have the record reflect things that I thought were going on that didn't seem appropriate. But I wouldn't voluntarily do that. That was definitely a COVID situation, or during the COVID time, and it made more sense for everybody's safety at the time. But I wouldn't voluntarily do that now. I mean, that it's just like trying to do court via video. It's not that it's impossible, but it is far better to be in person, read people's body language, read people's expressions, and see what's really influencing their testimony in a face-to-face situation. It just makes a difference in how you are able to ask the questions and perceive the answers.
Stress and all those things in a courtroom are very big indicators and things we use as really good attorneys to decide how we're going to go and where we're going to go. Videos take away that stress, take away the observation of body cues, ticks, hand movements, leg movements. Some people start tapping their leg. If you're on a video, you can't see that. And sometimes in a courtroom, you can't see that, to be fair. But I'm rocking all over the place. Sorry, folks, if I'm moving too much. But my point is this. I can't think of a time that I want a video over the real live thing for any reason. And there are things in the code that give you a right to video depositions. For instance, if the person's way out of town, lives in another state, those kind of things are reasons to do it. But I'm telling you right now, in our practice, in the number of years we've practiced, which, people have practiced a lot longer than us, we're not but we have a good amount of practice under our belt. And, when you're starting to get to 30 years, you've practiced a lot and seen a lot. And, I can't tell you how many times I've been in a courtroom where the body language gave me the clue to where I needed to go next, and literally won the case for me because I was able to perceive that. The tension in a courtroom, all those things make things come out maybe that don't normally come out, and you really do need that. Even in a deposition, I just think it's so important to have every element and to be able to read everybody in the room. Like Jackie said, sometimes there's some shenanigans going on and the attorney's trying to help the person answer and things like that, which is not okay. So anyways.
And that's, what you bring up a really good point. No, your attorney cannot help you answer questions. No, under any circumstance. No, not in a deposition. Interrogatories, requests for production of documents, they can't answer the question for you. They can help you with language to get the answer out that needs to be out, but they can't, in a deposition, they can't, write you a note and tell you what to say. In TV, you often see the attorney, say, hey, if I stomp on your foot, don't answer the question, or say you need to go to the bathroom. And really, that's not even really appropriate. It does happen, but an attorney cannot help you answer questions in a deposition any more than they can help you answer a question in court.
Yeah, that's very important, and that leads to our final point with this truth. I can't think. For me, one of the biggest things I've ever seen in depositions was the idea that somebody was trying to catch somebody in a lie to use it in court later to say that you lied about it. And I'll give you a prime example of something simple that people don't do. I once had a criminal case, and the guy was in depositions because of a certain situation. And he was doing lie detectors, and that was on being videoed. And One of the first things the guy asked him was, have you ever told a lie? And he said, no. I mean, what? I mean, it's just ridiculous because he thought he was under oath and he thought he had to, say everything was truth. Or they ask you stupid questions like, have you ever smoked marijuana when, and you have or you haven't. It doesn't matter if you haven't. I'm just saying be truthful. The answer to that question doesn't matter. And so what they're trying to do is get you to lie. And I'll give you one more example. I had a lady in a really bad traffic accident case one time who had some marital counseling at one time, way long time ago, and it was embarrassing to her. And when she was asked about doctors and counselors, she didn't say anything about it. And so later the other guy goes, hey, she lied. This is the record. She was clearly at counseling for 6 months with this and this guy. Because they can get things and records. And so it's just not worth it. If you're worried about a question, that's our job. We're good at it. I'd much rather you just tell the truth. Now I'll say this. This is super important too. Just because somebody asks you a question doesn't give them the right to the answer. And so truth is when you have to answer truth. Answer succinctly. Don't go off and try to justify or explain it. That's even worse. So, maybe, for instance, I realize marijuana is now somewhat legal and all those things, but it's a good example, like, especially from years ago, like somebody'd say, Jackie, have you ever smoked marijuana? Well, once, and I was really sick, and, my mom had just passed, and it just sounds like you're lying through your teeth at that moment.
Absolutely right.
You're trying to justify it. So, trying to think of a good...
Well, and, it's funny, though, is, do those answers matter if you lie about something like smoking marijuana, or you lie about, something that's not really directly related to the case? Does it matter? And absolutely it matters.
Absolutely.
If they can show that you've lied about something, they can cast doubt about all the things that you're testifying about, which is just about the worst situation you can be in if you're getting ready to go to trial. That's
what impeachment means. And it's that idea that if I can show that you're lying about one answer, that impeaches your testimony, which makes it less credible, and it follows that whole thread, and it's like, I don't want that.
Well, right now, they're airing part of this trial about some person who does like a video blog, or I'm not sure of his name, so I won't even say it. But he's on trial right now for, I believe, defamation of the mass shooting at Sandy Hook. And you're watching the judge, and the judge says to this person, you lied about this today, you lied about this today. Sir, you are in this courtroom, and you've been sworn to tell the truth, and you are not telling the truth. And you just don't understand the implications that that's going to have for him no matter what he says. And this is in front of the jury. She's telling him, I think the jury was still in the courtroom when she said, I've already seen you lie about these two things. Maybe the jury wasn't in there. Don't quote me on that, but it makes a difference. And of course, if it's a car accident, okay, and you're talking about injuries, and they're able to catch you in some sort of untruth, some sort of lie, or at least lead the jury to believe that you've been untruthful about something, the jury may have a hard time believing in, that you were really injured, for example, which is going to have an impact on how much money is awarded.
Yeah, it's just like this thing. There's something inside us sometimes when we're embarrassed about a situation or we're not proud of it that we don't feel like we need to share that. And I get it. Trust me, I do get that. But in a deposition, remember, there's only 5 people in a room, 6 people in a room.
Right.
The other attorney does this every day. He doesn't have time to go put it on his blog. This lady was in here today and said this and this and this. So it's not going to happen. I mean, that whole idea that you're going to be shamed and put out to pasture and all these kind of things is not a reality. And it's really important that you understand that. So in a deposition, just be truthful. Be succinct in your truthfulness. Did you smoke marijuana? Yes.
And if your attorney will have the opportunity for a follow-up question, how old were you? When was it? How many times? If it matters. If it matters. Right? I tell people a lot that if a judge has a question, or in a bankruptcy, if a trustee has a question, and they say, "Oh, I like your shirt. Where did you get it?" Right? This is a question no judge, no trustee is likely to ever ask, unless maybe it's pure gold or something silly. But they're not going to ask it, which is why I use it as an example. Where'd you get your shirt? I like it. Well, I first went to Kohl's and then I went to Target. I actually ended up, though, at Dillard's, and that's where I got it. No. The answer is I got it at Dillard's. That's
exactly. It. And, there's two kinds of people in the world, I think. Well, more than two, but I mean, what we experience a lot is the people who want to tell the whole story, like like she was saying, and then the other people who want to be so succinct almost to look like, did you have a gun, sir? Well, not really. And the answer is yes, they had a gun. So my point is just answer the question. Just say yes. And did you have a gun? Yes. Let me or the other attorney ask another question. Did you have back surgery when you were 20 years old? Yes.
I mean, it's not tricky.
It's not tricky, and it seems like it is. It seems like they're trying to lessen your case. Don't worry about that. Just be truthful. And if you think something's going to come up in that deposition that you're not excited about talking about, talk to your attorney first and say, hey.
Make sure they know, for sure.
I'll tell you the other thing, and we'll close with this, but, prepping for a deposition can go two different ways in life. And I always feel like I don't want to over prep people. If the truth is the truth, just tell the truth. And I don't want to get in that because then you look like you're trying to answer questions because I told you what to answer. And then you look like a liar again and It looks like it's not the truth. Like if you prepare your statements, well, if he asks this, I'm going to say X, Y, and Z. And then you're trying to remember, okay, I got to answer it this way. I went to the doctor in January, but I didn't do this and I did do, and then you just get confused. It's just so much easier to just answer the questions, especially in depositions.
Right.
I think that's a big mistake a lot of attorneys make is they over prep their witnesses. The witnesses start to feel like they're scripted and they're not real. Then you don't come off authentic to the jury, the judge, or anybody else. And again, that comes to that whole impeachment idea. When you don't sound authentic, when you don't sound truthful, when you don't sound real, it kills you. So just remember that we're here to help. Depositions are scary. Don't go into depositions alone. I often even think sometimes if you're being deposed as a witness, you may want to talk to a lawyer before you go into that deposition about what your liability could be. Sometimes, especially in civil matters, all of a sudden you get a charge against you because you went to deposition and that, said something you shouldn't have said. So Jackie, what are our takeaways for today?
Well, the first takeaway is what are depositions? What are they used for? And keeping that in the back of your mind as you prepare for them. And
the second one is why you're doing depositions. Again, it's discovery. It's a form of discovery to get more information.
And finally, the truth. Whether you're a witness or you're a party, if you're the person being deposed, it's important that you are truthful about all of the things you're being asked about, not just what you think is relevant to the case, but all matters. Be truthful in all matters.
All right, guys, thanks for listening. We have promised that we're going to do some of these cases that have recently come down from the Supreme Court. They're obviously big. We've gone through them. We are getting prepared to do some podcasts on those. They're very important decisions. A lot of people are misunderstanding the decisions and what they really mean.
And misrepresenting them.
And it's a big deal. So we plan on putting them out there and giving you our spin on them the best we can. Not spin, actually, the truth, what we believe they are saying. So we look forward to talking to you soon about those.
Tune in wherever you listen to podcasts and be watching for the mini-series on the changes in the law.
Like and subscribe.
Thank you.
Thank you. Bye-bye.
We hope you've enjoyed this episode of What to Do When. For more episodes, be sure to subscribe to our podcast, and we encourage you to check our archives to listen to previous topics. Tune in next week for a new episode and some fresh perspective from Critzer, Cardani.